Anytime that you have a hearing before a court official other than a judge, you can appeal that decision. Did you know that? That applies to a whole bunch of cases, and I'll explain. And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flesses. If this is your first visit to this channel, now may be the time to subscribe. By subscribing, you'll know where to go to get answers to your legal questions. In almost every state, small claims cases heard by an official other than a judge can be appealed directly to a judge. You have to check your state statutes and local court rules to see if this rule applies to you. And if that rule does apply, then an adverse ruling by an official other than a judge can be appealed directly to a judge. The legal term for this appeal is called a de novo review. That term means that a judge will look at your case like it's never been heard by any official before. It's a good way to challenge evictions for both tenants and landlords, prejudgment divorce hearings, and even debt buyer lawsuits that are heard before an official other than a judge. Using this appeal method actually gives you the opportunity to try your case twice. A court official other than a judge doesn't have the same authority that a judge has. If you had a ruling by a judge, the only appeal you could get is going to the next court level, which would be an appellate court. In cases that are relatively small ones, court systems don't want to tie up their court of appeals with small cases unless it's a legal issue that needs clarification. Court of appeal cases are also expensive and legally technical in nature. That's why a lot of courts allow you to appeal the small cases to a judge. This de novo review option can also be used in many states to appeal municipal court orders. That happens all the time for traffic citations or any other type of case that goes before a municipal judge. Let me give you a couple of examples of how you can use de novo review. To make this easier to understand, I'm going to use the term commissioner to be the official other than the judge. Let's say that you're a tenant and an eviction judgment is rendered against you by a commissioner, and you think the commissioner got the decision wrong, or you didn't have the evidence that you needed at your first shot at trying the case. Well, in many states, you can appeal that ruling to a judge. Another example would be a prejudgment divorce case. Let's say before the formal divorce hearing, there was an issue decided by a court commissioner that was adverse to you. For example, let's use temporary child support. If the ruling was adverse to you, you can appeal it to a judge, and the judge would hear your de novo review like the case was never heard by a court commissioner. Check your local statutes and local court rules to make sure you can do this in your state. I'm attorney Robert Flesses. Thanks for watching. Remember to subscribe, like, and share, and I'll see you in my next video.